Having explained my decision to enter a nolle prosequi in the case of the Republic versus Kwabena Adu Boahene and others, I wish to provide a brief update on the investigations and prosecutions that are currently underway. Trials have commenced in the case of the Republic versus Kwabena Adu Boahene and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the SkyTrain case. In the Kwabena Adu Boahene case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony. But for the 3rd accused person's sudden withdrawal in open court of her lawyer's service, our first witness would have been discharged to give way to the 2nd prosecution witness to start testifying. We expect our 2nd witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the SkyTrain trial, we have concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the 2nd accused person, that is Prof. Ameyaw Ekumfi, and recently of the lawyer for the 1st accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the SkyTrain case is expected to start before the beginning of the legal vacation. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use all advisedly, because as I have pointed out clearly, it is not in all cases that it is possible to recover all the loot. So you recover some, realistically possible. Of course, recovering the loot and jailing looters are not mutually exclusive. And I believe that that is what citizens are pushing for. In other words, both can take place, and that will be full-fledged accountability. But anyone familiar with the plea negotiations would agree that it is rare to go into the negotiation room and come out without giving up something in order to clinch a deal. Our plea bargain statute captures that succinctly, as it contemplates that the Attorney General may even go to the extent of dropping charges in exchange for restitution. Also, under the Costs Act 1993, Act 459, an accused may plead guilty to a charge or charges and pay restitution where the offense involves harm to the property of the Republic, including financial resources. In that case, the accused is to be handed a non-custodial sentence. As the Attorney General, I will not oppose the use of Section 35 of the Costs Act to achieve the purposes of oral. Now, Section 35 is mandatory. Once the accused approaches the judge, and pleads guilty to the charge, the judge is mandated, the judge could reject the restitution or reject the offer of the accused person. But once the judge accepts the offer of the accused person, I have no role in it, all right? Then the accused person must be given a non-custodial sentence. In other words, the accused person will walk home.